Hello friends, my name is Lalit Soni and you are watching Polity This week by Drishti IAS. In this episode, we will be discussing the important developments which has happened in the field of polity and which can be important for your examination. So let's start our discussion. Here in today, we'll be discussing four topics. Okay, so we'll be starting with the appointment of the new CEC, that is Chief Election Commissioner. So we'll be talking about that. We'll be seeing that what was the old procedure, what is the new procedure, because this appointment has happened with the new procedure. So we'll be looking into both the old procedure and the new procedure, and then we'll be moving to the next one, that is Article 101 clause 4, that is provision on the absence. When you are talking about the MPs or MLAs, so there is this provision which is there in the constitution, that is 101 clause 4, specifically speaking, that is about your MPs. Okay, so if an MP is absent from the house, what will happen in that case? So we'll be talking about that. Then coming to the next one, remission without application. So basically remission is something which you should know, that is some kind of relaxation which is there from the imprisonment. So we'll be talking about that. It is under the pardoning power of the president and the governor. So we'll be seeing that why it has been talked about recently. Supreme Court has made a comment on this, that if there is a state which is having a remission policy, they should go for it. They should not wait for the application from the, you can say, the prisoner or from the family of the prisoner. Okay, so that is there. And in the end, we'll be talking about the Lokpal versus Judiciary tussle. Recently there was this incident which has happened, that the Lokpal has issued an order, and after that Judiciary has put a stay on that particular order. So here we'll be talking about this particular aspect. Okay, so we'll talk about the Lokpal and the some of the provisions which are related. Okay, now let's move further and start with our discussion. Before that, we will be seeing that we have already seen the news, so we'll be starting with the appointment of the new CEC. Okay, Chief Election Commissioner. When we talk about, we have Election Commission which is looking into the elections of various important posts like president, vice president, and other, you can say, parliamentary membership, etc. So these elections are basically supervised, direct, and controlled by the Election Commission. And in Election Commission, we have members, we have Chief Election Commissioner. So we will be talking about all these things. Okay. So Gyanesh Kumar has been appointed as the Chief Election Commissioner under the Chief Election Commissioner and the other Election Commissioner Appointment, Condition of Service and Term of Office Act 2023. So here, that is about an act which has been enacted in 2023. So if the act has been enacted in 2023, what used to happen before that? Okay, so we'll be talking about that. So that is the old procedure, and we'll be looking into the old and the new one. Okay, constitutional framework for appointment governed by the Article 324 grants the Election Commission of India the power of superintendence, direction, and control over the elections. I already told you that when we talk about few posts over there, they will be, supervising, and superintendence power is there, direction power and the control power is there with respect to the you can say election. It has been given to the Election Commission. Okay, so important article over here is that Article 324, which you cannot miss. Okay, coming to the next one, the Chief Election Commissioner and the Election Commissioners are appointed by the President of India. They are appointed by President of India. They will be removed by President of India, but removal procedure also has the parliamentary scrutiny. That is there. Now let's move further to the next part, that is what is the appointment procedure. Now before that, before the act, what used to happen is that the executive had the hold of that, and after that, that case goes to the Supreme Court. Supreme Court makes a selection committee. Okay, so selection committee was PM and the leader of opposition. If leader of opposition Lok Sabha is not there, in that case, the, you can say, the leader of the largest opposition party, leader of largest opposition party will be member of this selection committee. Along with that, the CGI himself will be part of this particular selection committee. Okay, that was the case, and Supreme Court has said till the time center comes with a law, this will be the selection committee for the appointment of the CEC. Now, after this judgment, central government, incidentally, they brought the law, and that law was the one which was enacted in 2023, which I just told you. That is, the name of the law is the Chief Election Commissioner and the other Election Commission Appointment, Condition of Service and the Term of Office Act 2023. Now, this new appointment has been made with respect to the provision of this particular act. Now, what is the provision in this particular act? So, there will be a search committee. Now, this is the selection committee earlier, which was there, selection committee. Okay, now there will be a search committee. What this search committee will do is that they will look into the potential candidates. Okay, and they will forward this list to the selection committee. Okay, so they will be providing the list to the selection committee. But the thing is, they have mentioned a new constitution of the selection committee. The new selection committee will be there. Okay, so what is the membership, or the what is the constitution of new selection committee? So in this new selection committee, there is Prime Minister, there will be leader of opposition, or the leader of largest party in the Lok Sabha, that will be there. And other than that, there will be a union minister which is nominated by the PM itself. Okay, so these three members will be there in the selection committee. Now what is the procedure? The search committee will be looking into the potential candidate, they will be giving the name to the selection committee, and selection committee, out of these names, they will be going for the selection of the new CEC or other members. Okay, that is the selection procedure. Once they decide the name, they will be sending it to the president will be the authority to appoint the particular person as the authority. Okay, so that is there. So that is about the new selection committee. It will be comprising of the prime minister, the union cabinet minister, and the leader of opposition or the leader of the largest opposition party in the Lok Sabha. Okay, so that is there. Other than that, there will be a search committee which is given over here. Search committee will be under the leadership of law minister. Okay, so I hope that is clear. This is the process of appointment. Now coming to the Election Commission of India, this is some of the basics which is there. Article 324 we have already seen, that is given over here. Article 324 to 329 is dealing with the you can say Election Commission, that is given under the part 15, that you should remember. Coming to the next one, it is an autonomous constitutional authority which is there, which administered the elections related to the Lok Sabha, Rajya Sabha, state legislative assemblies, the offices of the president and the vice president. One more important factor I would like to tell you over here is that we have, you can say, National Election Commission of India or Election Commission of India, which we have at the national state, you can say national level, and at the state level we have state election commissions. Okay, state election commission. Now do not get confused that election commissions of the states are responsible for the election of the state legislative assemblies. Okay, when we talk about the legislative assemblies, they are not responsible, they are responsible for the local elections like panchayat and the municipalities, etc. Okay, so that is there with respect to election commission of the states. When we talk about the elections of the legislative assemblies, that are responsible for responsibility of the election commission of India only. Okay, so here election commission of India will be looking into the elections of Lok Sabha, Rajya Sabha, state legislative assembly, the offices of the president and the vice president. Okay, that you should remember. Establishment date, if we talk about, that is 25th of January 1950. That is also known as the National Voters Day. Okay, I hope that is clear. Now let's see what is the structure. Structure is that we will be having one CEC, one Chief Election Officer, Chief Election Commissioner, and then there will be two ECs. Okay, that is election commissions. These are appointed by the president. Tenure will be 6 years. Age is 65 years. Up to 65 years you can be member of the, you can say, election commission. Now whichever is earlier, that obvious is there. Retiring ECs, when we talk about, so retiring ECs are eligible for the appointment of the when we talk about the further appointment under the government of India, that is there. Coming to the next one, removal of CEC. When we talk about the removal of Chief Election Commissioner, that is resolution on the ground of the proven misbehavior or incapacity. There are two grounds. Now these grounds are similar as the judges of the Supreme Court or the High Court. Judges of Supreme Court or High Court, the procedure is kind of similar over here. So there will be resolution on the ground of proven misbehavior and the incapacity with majority of 2/3 members present and voting and supported by the 50% of the total strength of the house. That is the special majority which is required over here. Okay, so that is about the removal procedure. We have seen the appointment procedure. So that is enough from your election commission's point of view. Here some of the responsibilities and roles are given which you can go through, which is generally conducting elections, preparing the electoral rolls, voter ID card, all these things are related over here. And when we talk about the moral code of conduct, all these things will be implemented by the Election Commission of India. So that you should go through it. Now moving further to the next one. Before that, Drishti IAS is offering you IAS Foundation course for prelims as well as mains at our new center, that is Noida Sector 15. Here batches will be there in the offline mode. For English medium, batches are already started, admissions are open. When we talk about Hindi medium, batches are starting from 21st of February, so you can directly go there and take admissions over there. Okay, so that is about it. And when we talk about the address which is given over here, you can directly visit the center and get yourself enrolled, or you can call us on 87501 87501. Okay, now moving further and looking into the next discussion, that is Article 101 clause 4, provisions on the absence of the MPs from the house. Okay, so let's see. What was the issue recently? Recently, one MP, particularly from Punjab, he has been in the jail and he has contested elections from the jail and he has won the elections. And after that, also he is under the detention. He has only attended 1 or 2 sessions for of the house. And other than that, when we talk about the absence, that has amounted nearly 50 days. Okay. Now, in the constitution, there is a provision that if a MP is absent without a notice to the house for more than 60 days, then in that case the that particular seat might become vacant, okay, because parliament will be taking a decision on that. Okay, so let's see what is the provision which has been given over here. Article 101 clause 4, provisions of the on the absence. If an MP is absent for 60 days without permission, okay, one thing is that without permission, you can take leaves. Now these leaves are with permission, okay, and if there is a person who is there without permission, absent from the house for 60 days, then in that case the house may declare the seat vacant. Again, this is a may, okay, there is a possibility that they can declare the seat vacant, but it is not necessary or mandatory part. Okay, again, if there is a person who has applied for the leaves, there is a committee, okay, that committee will be looking into it and then they will be recommending the house on the acceptance or the rejection of the leave. Okay, so that is there. Coming to the next part over here, that the 60 days over here, which we are saying that if a particular MP is not present in the house for 60 days, his seat might be declared you can say vacant. But this 60 days period excludes the time when the session or the house has been adjourned or prorogued more than 4 days consecutively. Okay, so basically if the house has been you can say adjourned or the prorogued, and that is more than 4 days, so that particular period of time will be excluded from the count of these 60 days. Okay, so that is there. The absence is counted only for the actual sitting of the parliament. Okay, coming to the next one, leaves and the exceptions. MP can apply for the leaves through the committee on absence of member from sitting of the house. The committee reviews the application, which are then ratified by the house. Ultimately, this particular application will be ratified by the house only. Past record shows that MP have not been granted leave for illness and imprisonment. Okay, sorry. MPs have been granted these leaves. So in the past, we have seen that for illness of self as well as of the family members, the leave has been granted for the imprisonment and the illness. Okay, so that is there for 101. Now, no automatic disqualification. As I told you that if this MP is absent for 60 days, parliament may go for vacating that particular seat. But again, that is not automatic. Parliament has to decide on that. Okay, even an MP exceeds 60 days of the absence, the house must vote to declare the seat vacant. Okay, so house has to decide over there, and they will not directly just because 60 days has passed without any kind of you can say notice, they cannot automatically declare the seat vacant. They have to pass a resolution that they have to declare it vacant. Okay, coming to the next one, no past precedents. In the earlier or in the past, there is no such incident which has happened. This makes it unlikely that the Amritpal Singh, that is the MP I was talking about, that he will lose his you can say seat, or his seat may be you can say vacated. Okay, so that is not the case over here, because he has nearly been in jail, or you can say out of the session, for 50 days as of now. So that is there. Anyways, what is the important thing over here is that the time you should remember, that is 60 days is there, and then there is no automatic disqualification. Parliament or the house has to pass the resolution in that regard. Okay, so that is there. Other than that, that is all these things are for the case where without any permission you have taken, or you have been out of the session of the house. Okay, if you have taken the permission, then this does not matter about the 60 days. Okay, coming to the next one, Article 101 of the vacation of the seat. Okay, now in that there are other provisions as well. So let's see, first is the dual membership in the parliament is prohibited. So that is given in the clause 1 of the Article 101. So clause says a person cannot be member of the house of the parliament, okay, both houses of the parliament. He cannot be the, you can say, member of Lok Sabha as well as Rajya Sabha. He has to be, or he has to choose one place over there. Okay, so that is there. Coming to the next one, conflict between the parliament and the state legislature. If we are talking about a person who has been elected as a MP as well as an MLA, okay, so he has to actually vacate one seat. Okay, he has to do it within a specified time. Over here there is this president's rules are there. As per president's rule, he has to leave that particular seat, one of the seat over here. If he does not, in that case his parliamentary seat is considered as vacant. Okay, so he will stay as the MLA of the state assembly. So that is there. So it is given that a person cannot be member of both parliament and the state legislature at the same time. If elected to both, they must resign from one within a specified period of time. They must resign from one seat within a specified period of time. If no resignation is given, the parliamentary seat automatically becomes vacant. Okay, so that is there. Coming to the next part, that is your article 1013 subclause A. When we talk about the article 101 clause 3, it is talking about a seat becomes vacant if a member becomes disqualified under article 102 clause 1 or 102 clause 2. So basically that is basically talking about your office of profit. We will be looking into that article 102, but right now I'll just telling you that that is with respect to your office of profit. Then talking about article 101 clause 3 subclause B, a seat also becomes vacant if the member resigns in writing to the speaker or the chairman of the house. Basically they are saying that if a person is resigning to the chair of the house, so and the chair is accepting the resignation, in that case also the seat becomes vacant. And if the chair finds that the resignation is not voluntary or it is not genuine, in that case they might reject the resignation. Okay, so that is about the third one. Coming to the fourth one, absence without the permission. This clause we have already discussed. This is basically article 101 clause 4, which we have seen in the start of the discussion. Now coming to the next one, that is article 102 clause 1 subclause A, that is saying a person shall be disqualified from being a member of either house of the parliament if he holds any office of profit among or other grounds. So basically that is your office of profit. If a person is holding office of profit, then he will be his seat will be declared vacant. Then coming to the article 103 says if a question arises whether a member has incurred such disqualification or not, the president will be the authority over here. President will be taking the opinion of the election commission and accordingly he will have to act. Now this is about the disqualification which is under article 102 and 103. And when we talk about the anti-defection law which is there under the 10th schedule of the constitution, in that regard the speaker will be taking the decision. Okay, so that is there. And when we talk about the state legislatures and the you can say councils over here, so article 191 will be having the similar provision. Okay, so that is about the you can say vacation of the seats which we have seen. Now coming to the next one, remission without application. Now recently Supreme Court has made an observation and they have guided the state governments that they have to make rules with respect to the remissions if they are not having it already, and if they are having a rule then they have to grant the remissions. They do not have to wait for the application from the prisoner itself. Okay, so let's see. Definition of remission. Remission reduced a convict's sentence under the section 473 of the Bharatiya Nyaya Suraksha Sanhita, that is BNSS. Earlier it was there under the section 432 of the CRPC. Okay, so that you can remember, that is 473. Now some states impose condition for the remission such as good behavior and the periodic reporting. So such states are having these rules which are already there. Okay, coming to the current news, that is Supreme Court stand over here. Earlier the Supreme Court held the remission cannot be granted suo motu. Earlier the Supreme Court has said that the suo motu you cannot grant the remissions, but now they have changed the position that they have said that if state is having law, if the state is having a policy that exists for the remissions, authorities must consider the eligible convicts automatically and fairly. They do not have to wait for the application from the friends or the family or that particular you can say inmate. Okay, so that is there. Directive to the state. What direction has been given to the states from the Supreme Court? The state must create a detailed remission policy within the 2 months. Okay, if they do not have the policy, they have to make a detailed policy within 2 months. Policy should be a balance of public safety, criminal background and the rehabilitation. So basically they have to make sure that there is public safety. You are releasing a convict which is basically you can say eligible to go out and be part of the mainstream societies. Okay, so that is there, that you have to consider the public safety and the criminal background, etc. Coming to the next one, conditions should not be too strict. Okay, ensuring fairness under the Article 14. Article 14 is basically right to equality. Coming to the next one, discretionary power within the fairness. The court emphasized that the remission power under the section 432 clause 1 must be exercised in a fair and reasonable manner. Government must incorporate suitable conditions while granting the remissions, which we have already seen that these conditions should not be too strict. The conditions should be balanced justice and the societal safety. What we are talking about over here is that you have to balance the public safety, rehabilitation, and the criminal background over here. Okay, so that is about the directions which has been given. Now let's talk about the type of pardoning power. When we talk about the remission is one of the pardoning power which is there, and which is with the, you can say, governor and the president. Now let's see what kind of pardoning powers are there. Okay, so let's start with the first one, that is pardon itself. These are basically under your mercy petitions. Okay, mercy petitions, which is also a power of the president and the governor. So we have first one, that is your pardon. Pardon is basically you are absolutely making that particular person free of any kind of conviction. There is no sentence, nothing at all. So here you can see completely absolve the convict of the crime, erasing all the convictions and all the associated penalties. So no crime, it is like a person has never committed a crime. Okay, so that is something like that. So you have absolved that particular person from any kind of sentence or the fine or penalties. Okay, so here you can say the president grants a pardon to a person wrongly convicted of, you can say, prison. So basically what they are saying is that the wrongly convicted. The idea over here is that if the judiciary in somehow has, committed some kind of error, in that case that particular person should be given another chance. Okay, idea is not to let go of the criminals free. Idea is to make sure there is no error has been done from the judiciary. If at all there is an error, then that can be made right by the president. Okay, so that is the idea, that if a person has been wrongly convicted, in that case you can go for the pardon. Coming to the next one, here one more thing I would like to tell you is that when we talk about the pardoning power, the pardoning power of the presidents are more than the governor. Okay, president can pardon a death sentence as well, but governor cannot pardon a death sentence. Governor can pardon any other, you can say, imprisonment or any other punishment, but he cannot pardon the death sentence. He can remit the death sentence, he can commute the death sentence, all these things he can do, but he cannot absolve a person who has given a death sentence. Okay, so that is there. Coming to the next one, that is commutation. Commutation means that you are actually, changing the nature over here. Substitute a harsher punishment with a lighter one. Okay, so here what you are doing is that you are changing the nature of the punishment. Let's say if there is a person who has been given a death sentence and you have converted it to the imprisonment, okay, life imprisonment, that is basically commuting. You have changed the nature of the sentence. Coming to the next one, or you can say, let's say if there is a person who has been given the imprisonment of the 3 months, okay, and you have converted that into a fine, that is also a commutation. Coming to the next one, remission. Remission is that the nature will be same, but the time will be reduced. The time of the sentence will be reduced. So here you can see, reduce the period of the sentence without changing the nature of the punishment over here. So the governor remits 1 year from a 2-year sentence of the rigorous imprisonment. A person who has got the rigorous imprisonment for 2 years, you have actually remit 1 year. Now he has to serve only 1 year. Okay, so that is there. Coming to the next one, that is reprieve. So in the case of reprieve, what you are doing is you are temporarily postponing. Okay, temporarily postpones the execution of the sentence, usually for the shorter period. Okay, so you are temporarily going for the postponement. Okay, so the president grants a reprieve to a condemned prisoner to allow them time to file a mercy petition. Okay, so you are giving extra time to that particular person before he starts to serve the sentence. Coming to the next one, that is respite. Now respites are given for a specific reason, and that can be more than, you can say, shorter period. Okay, so that can be for the, longer period as well. So similar to reprieve, but longer period can be there, often for the medical reasons. Okay, so a governor grants respite for a temporary terminally ill prisoner to allow them to spend their final times at homes or at the hospital. So that is basically your different type of pardoning powers which are there. Now when we talk about the difference between president and the governor, over here you can see that president can pardon, reprieve, respite, remit, suspend or commute the punishment or the sentence of any any person convicted of any offense against the central law. Here one thing is that he will be doing this for a person who has committed an offense under the central law. Coming to the next one, when we talk about the governor, he can do all such things under the state laws. Okay, so that is there. The power over here is limited to state laws when we talk about the governor. Coming to the next one, he can pardon, reprieve, respite, remit, suspend, commute a death sentence. Here you can see, here he can pardon also. But when we talk about the governor, governor cannot pardon, okay, but he can go for the other aspects over here, but he can suspend, remit or commute of that sentence which is there. Coming to the next one, when we talk about president, president can do all these things in the case of the court martials, or the when we talk about the military laws or military courts, he can do for the judgment or the punishment which has been given by the court martial or the military laws, that can also be done by the president, but that cannot be done by the, you can say, governor over here. Okay, so I hope that is clear. Now let's move to the next part, that is Lokpal versus judiciary. Now recently what has happened is that Lokpal has given an order which is investigating into the you can say jurisdiction of the high court judges over there, and that order has been stayed by the Supreme Court, saying that this is against the independence of the judiciary. Now there was this tussle which has started, so Supreme Court will be hearing the matter. Okay, so we will be looking into the Lokpal over here. So here you can see legal interpretation. If we talk about, so one side is saying that since high courts are also, constitutional bodies, and they are also having some kind of origin which can be traced to the constitution, so these are also these are not under the ambit of the Lokpal over here. Here you can see one side argued that the high court judges are part of the constitutional structure, and that is why cannot fall under the Lokpal. That is one argument. Against that, there is another argument which is saying that the high courts are basically having its origin from the laws which are dating back to the colonial time. Okay, so considering that these are not, part of the constitutional structure, and that is why they are under the Lokpal's ambit. Okay, but when we talk about the Supreme Court, Supreme Court's origin is traced back to the Constitution itself. Okay, when we talk about the High Courts, there was this mention of the High Court in the, you can say, there was this old act like 1773 Act and then 1935 Act. The mention of High Court is there. Okay, the provinces like Bombay, Calcutta, Madras, they were having High Courts already. So this is the colonial provisions which were there. So that is why they are saying that that is not tracing its origin from the Constitution, and that is why they are under the ambit of Lokpal. But Supreme Court has been tracing its origin from the Constitution itself. That is why that the judges of Supreme Court will not be under the jurisdiction of Lokpal. That is another argument. Again, I'm telling you, these are the arguments and not the position. Position will be decided by the Supreme Court when they will be hearing the matter. Okay, so as of now, this is just one of the argument. Coming to the next one, Lokpal Act 2013. It does not explicitly mention the High Court judges in the Act. So that is why they are saying that because of that also they cannot look into the investigation of the High Court, investigation into the High Court judges as well. So that is there. Coming to the next one, Veeraswamy judgment, that is from the 1991, which is saying that if you are going for any kind of investigation in the criminal matter against a High Court judge, you have to take the prior approval from the CGI. Okay, so that is there. So considering that, these arguments are basically trying to put forward the notion that the Lokpal does not have any kind of you can say authority to look into the conduct of the High Court judges and the Supreme Court judges. Basically, when we are talking about the Constitution itself, so there are only two ways a judge can be scrutinized. One is the internal committees which are there, and other than that we have the impeachment like procedure. Okay, so only in these two cases you can go for the questioning the conduct of a judge, but Lokpal etc. are not having that kind of authority. So that was there. So what is the position of Lokpal over here? Lokpal has said that it has only examined the jurisdictional issues. They have not gone into the allegation against the High Court judge. They were only looking into the jurisdiction. Okay, so that is there. Also, they are saying that we acknowledge that the any probe which is against the judge of the, you can say, High Court or Supreme Court, that require consultation with the CGI. Okay, so they are acknowledging that, but they are saying that we have only looked into the jurisdiction and not into the allegation. Okay, so that is the issue. Now Supreme Court has taken a suo motu cognizance of that particular order which was passed on 27th of January. And they are saying that they will be looking into it in the upcoming days. Okay, so that is about it. Now look into the Lokpal. Okay, now when we talk about Lokpal, Lokpal is a body which is looking into the issues of the allegations of the corruption against the public offices or the public servants. Okay, so what is the jurisdiction over here? First, that is we are having this act, that is Lokpal and the Lok Ayukt Act 2013. Okay, seek to establish institution of Lokpal at the center and the Lok Ayukt at the state. Okay, jurisdiction has been given, that is Prime Minister, MPs, Group ABCD services, and the official at the central government. Other than that, if there is an institution which is having funded by the government or the partially funded by the government, in that case also they will be having the authority over there to investigate the allegation of the corruptions. And then if there is a body which is getting more than 10 lakh rupees donation under the FCRA Act, foreign donations, in that case also they will be scrutinizing that as well. Powers are given over here, you can go through this. So basically these powers are to go for the investigation. If there is an investigation authority which has got the case from the Lokpal, so they will Lokpal will be having the superintendent's power over there as well. So that is there. Coming to the next one, other than that, there is this provision of attachment of the property which has been actually purchased from the black money or the money related to corruption, even when the prosecution is going on, conviction has not been done. Coming to the next one, when we talk about the appointment, so there is the selection committee. So in the selection committee, there will be PM, Speaker of the Lok Sabha, leader of the largest opposition party in Lok Sabha. Okay, other than that, CGI will be there. Okay, if CGI is not there, though, there will be a Supreme Court judge which is nominated by the CGI will be sitting there, and then there will be an eminent jurist which is nominated by the president. Okay, so that is the appointment committee which will be appointing the members and the you can say chairperson of the Lokpal. When we talk about the structure, so there will be a chairperson and maximum 8 members will be there. Out of 8 members, 50% should be from having a judicial capacity or from the they will be judicial members, and other 50%, or when we talk about these 8 members, 50% should be from the SC, ST, OBC, minority and the women community. When we talk about the term of office, that is 5 years and until the age of 70 years. Okay, so that is about your Lokpal and all. Now, in the end, we have a practice question for you under Article 101 Clause 4. What is the consequence if an MP is absent from all sittings of 60 days without prior permission? The president removes the MP automatically. The MP is permanently barred from the re-election. The House may declare the seat vacant through a vote, and the Election Commission conducts a re-election. Okay, so you can attempt this question and answer to me in the comment box. With that, I will take your leave. If you have not subscribed the channel, please subscribe it. Have a nice day. Thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.